This is Barry Wood. I'm the Assessment Division Director for the DLGF. As Jenny indicated, we appreciate your feedback on classes, and so we thought this class on not-for-profits and exemptions would be a timely class, especially if you had the opportunity last month. Emily Chrysler and Dave Marusars from our legal department gave a presentation on deductions, and so we thought it'd be a good idea to sort of piggyback the two. Just wanted to remind everyone that deductions and exemptions are not synonymous. Deductions just result in the lowering of a person's tax bill or tax liability, such as, say, the homestead deduction or over 65 deduction, whereas exemptions, primarily for not-for-profits, results in the taxpayer, the entity, not paying taxes, and that tax liability responsibility is picked up by other taxpayers in that jurisdiction. So without further ado, I'm not an attorney, but we do have to give this disclaimer that this presentation and other Department of Local Government Finance materials are not a substitute for the law. The following is not legal advice, just an informative presentation. The Indiana Code always governs. So today we're going to talk about definitions. We'll talk about exemptions, address common issues and problems, talk about case law updates and review, cover frequently asked questions, and then hopefully we'll have enough time at the end to cover questions that you may have. One key thing I wanted to point out is the DLGF does not get involved in individual property tax assessment or appeal issues, or in this case, say exemption issues. The reason being two sides to every story, and we may not have all the information to provide succinct guidance, and certainly we give deference to local control and also the appeal process. If you ever email me or call me, one of the things I will frequently do is refer to the Indiana Code for reference, and in particular for exemptions for not-for-profits. The main piece of legislation that was passed that addresses exemptions is Indiana Code 6-1.1-1016. And you can see paragraph A talks about that all or part of a building is exempt from property taxation if it is owned, occupied, and used by a person or for educational, literary, scientific, religious, or charitable purposes. So that is pretty widespread, pretty encompassing. We will talk in a little bit about some specific entities that are by statute exempt, but this is the main area where not-for-profits will use to declare or to state that they should be exempt for property taxation. Also, you can see in paragraph B, if the property is owned, occupied, and used by a town, city, township, or county for educational, literary, scientific, fraternal, or charitable purposes, it is exempt as well. You can see then in terms of campus for educational institutions is exempt. And then getting into further areas is one of the things that we find is not-for-profit, say a church, for example, will buy a tract of land for potentially building a new church or a building or whatever the case may be. That tract of land would be exempt if there are a couple of key things here. It's owned, occupied, and used, that the building will be exempt under subsection A or B that we just referenced. And then timing is key here. Not more than 4 years after the property is purchased, and for each year after for a 4-year period, so a total of 8 years, the property owner must demonstrate substantial progress towards building the building, so to speak. And to do that, they must prove that they're doing that by a variety of ways. One is, do they have a building committee? Have they filed building plans with the appropriate legal government authority, such as the building commission? Do they have building funds, cash reserves set up so they can start construction within 4 years? Have they broken ground on the building? And anything else that would lead a person to believe that they are in the process of building and completing that structure within an 8-year time frame. If the owner sells or otherwise transfers the property of that land, that tract of land that was exempt, then that owner would be liable for the taxes. And here's where the assessor would need to work with the auditor to ensure that the assessment, the taxes are applied appropriately. And you can read through and see what would transpire with that. Personal property is also exempt if it were exempt, like a building. So if it's a church or not-for-profit, the personal property would also be exempt if they met the criteria. We'll talk in greater length later about hospitals and medical facilities, but typically a hospital's property is exempt as long as they meet certain criteria. And one thing I'll emphasize repeatedly throughout the presentation is that even though, say, in this case, the hospital organization claims that they're exempt from federal income tax under, say, Section 501c3, any not-for-profit, even though they may say we're tax exempt for federal tax exempt purposes, does not mean they're necessarily exempt for property taxation in the state. So if an entity, a not-for-profit says, oh, well, we're a 501c3, that's fine, but that does not automatically give them property tax exemption. In terms of a practice group of physicians, sometimes you'll see hospitals with the office building or property that is affiliated or associated with the hospital. That does not mean it's automatically exempt either. So you have to look at each case on a case-by-case basis. In terms of the healthcare industries, are they providing, and we'll talk about a case later on, are they providing care for indigent individuals, and is there a community benefit for that property? Just because a hospital or a healthcare program or facility participates in Medicaid or Medicare, that does not automatically entitle them to an exemption either. Another area that you may encounter is this provision for community housing, or in this case, individual housing. So in this case, think of, say, Habitat for Humanity, and that property may be exempt. However, that exemption would terminate when the property is conveyed by the nonprofit organization to another owner. When property, much like we talked about the land tract for not-for-profit changing, when property that may be exempt is conveyed to another owner, say like a Habitat for Humanity, then the assessor should work with the auditor in terms of ensuring that the property taxes are payable, or however that's be worked out. I won't bore you and read through, but you can see the different criteria in terms of the residency requirements and the transfer for low-income individuals and the interest rates. As you can see, then it ultimately becomes a lien on the property if the amount collected is not, or the amount assessed and due is not collected. Another area that we get questions on for not-for-profits is for early childhood education providers for daycare. And a couple of years ago, the General Assembly gave stipulations in terms of exemptions for those childhood education services that provide education for children in at least 4 years old, but less than 6 years of age, in terms of exemption and being exempt. However, this would not necessarily be for those providers that have for children under 4 years old. So one of the things you need to look at if you have a not-for-profit that is a child care provider is what are the ages of the children participating or attending at that facility. One of the other, I mentioned, talking about various things, looking on a case-by-case basis. One of the other things we'll talk about extensively today is predominant use. And Indiana Code 6-1.1-10-36.3 talks about predominant use. And you can see in paragraph A, it talks about that if the property is predominantly used or occupied for one of the purposes more than 50% of the time, then it would be exempt. And the determination of this is made obviously on the use or occupancy of the property, and for the taxpayer, the entity applying for the exemption to separately show what parts of the building or facility or properties are exempt. One of the key things about this is that timing is the key thing in terms of when the taxpayer, the not-for-profit, applies for exemption. They should create or have time logs to show how much time the property was used for exempt purposes, and they would be doing that for the prior year. So if a taxpayer, a not-for-profit, applied for tax exemption for the January 1st, 2024 payable 2025 assessment date, they would be looking at what was the predominant use of the property in calendar year 2023. There are a couple caveats to this that we'll talk about. The first is that for a religious entity, society, church, whatever the case may be, if it is predominantly used for religious purposes, then it would be 100% exempt throughout the year for that entire year. If you have another entity, not-for-profit, whatever it may be, but it's not a church or religious society, then it becomes what is the predominant use? Is it 60%, 70%, 80%, whatever the case may be. Again, it's case-by-case, fact-specific for the property. If the property is not used or occupied during the time frame predominantly for that exempt status, then obviously it would not be exempt. In terms of hospital facilities or healthcare facilities, there are a couple different Indiana Code citations. You can see the first one dealing with hospital bonding authorities, and authorities not required to pay any taxes or assessments for the hospital bonding authorities would be exempt. And then also several counties throughout the state have county hospital building authorities, and that property owned by the building authority would be exempt from taxation. Excuse me. So Indiana Constitution, Article 10 allows the legislature to grant exemption for municipal, religious, charitable, educational, literary, and scientific purposes. As I mentioned at the start, there are some specific exemptions that may not be included in Indiana Code 6-1.1-1016. We talked about, for example, daycare facilities, and other may be fertilizer storage exemptions, and there are also several others. One obviously starts with property owned by a political subdivision, be it a state, a county, a township, a city, municipal property, that would be exempt specifically by either 6-1.1-10-4 or 10-5. The key is that the property must be used for a municipal purpose. And in this situation, the taxpayer, say the city of or the town of, they do not need to file a Form 136 exemption application. There are some entities, not-for-profits, that are specifically exempt by statute. You can see, say, the YMCA, Salvation Army, if you have an American Legion post, property owned by the Boy Scouts or Girl Scouts, that would be exempt specifically by statute. So I mentioned a few minutes ago the predominant use. And what is the predominant use? Well, Predominant use basically means that property must be used more than 50% of the time for one of the exempt purposes. If it's used less than that, then they do not receive, taxpayer, the not-for-profit does not receive any exemption at all. I mentioned that if a religious institution, church, mosque, whatever the case may be, if it's used more than 50% of the time for religious purposes, then it automatically would receive a 100% exemption. And if the property is not used for religious purposes, but for other exempt purposes, this is where the predominant use comes into play, and looking at the time logs or the time records to show how much of the time was the property used for an exempt purpose. Say 65% of the time it was used for a charitable use, and so they would get then a 65% exemption. If it's a mixed use property, mentioned, keeping track through time records, and the amounts can vary. It could be 100%, and it could be 85% charitable use and 15% non-exempt use. So the taxpayer would have to be able to quantify and show and prove, here's how much time the property was being used for a charitable use, and here's how much time it was not being used for charitable use. Most of the exemptions that get appeals that get filed at the Indiana Board of Tax Review and tax court level primarily focus on the charitable use. And one thing I do want to mention is any and all of the Indiana Board of Tax Review decisions are posted on their website, as well as the tax court determinations. You can go on and do a word search and type in not-for-profits or exemptions, and they'll come up with a lot of the cases that have been decided. So that might be a good way to determine or find out, what's going on. Would my property meet, fall in line with what a IBTR decision may have been on, a prior, similar situation. In order to meet or have an exempt purpose, it must be owned, occupied, and used. So what are some examples of something that automatically you would think, yeah, this entity, this not-for-profit would qualify? Well, the first example is you have a property that it's used 100% of the time by a not-for-profit food bank, excuse me, to provide food at no cost to those in need, and the property is owned by the food bank. That would be a pretty much shut and dry, shut and closed case. You may have a situation where a not-for-profit provides medical services for free to those in need, using their property exclusively for the work, and they have volunteers. That would be another open and shut case where it would be exempt. And I'll keep repeating myself throughout, but you have to look at it on a case-by-case, individual basis. There's no carte blanche. Just because you're a food bank, you get automatically exempt, or just because you're a not-for-profit providing medical services, you get exempt. You're exempt. So what happens if you change the fact patterns around? So if this food bank was property, it's used 55% of the time by a non-for-profit food bank, they do not charge their clients anything. What happens if it's now split and 45% of the time the property is used by, rented to a for-profit business selling its own food products? This is where the predominant use would come into play, and they would probably receive a 55% exemption for the property itself. If you have a for-profit business and it's not a not-for-profit that owns an empty building that it is not using, and the company decides to provide it rent-free for 5 years to a charity that uses it 100% of the time for services for the poor, would that be exempt? Probably, but again, it would be a case-by-case decision. So if you're an assessor, or if you're a Property Tax Assessment Board of Appeals member and you're looking at an exemption application by a not-for-profit, what should you be looking at? How do you make a determination whether or not the property is exempt? First, look at the exemption application. Did they fill it out completely? Under what code citation do they state that they're eligible? Charitable, religious, educational? What organizing documents do they provide? Do they include articles of incorporation, bylaws? Do they provide their tax forms? Have they provided time records like we've talked about, especially if it's a mixed use property, to be able to quantify that they are indeed 85% of the time, 100% of the time providing charitable purposes, uses, and that's why they should be exempt. As I mentioned a minute ago, look at case law from the IBTR, from the Indiana Tax Court. Not much has changed in terms of exemptions here and there over the past few decades. So certainly looking at prior cases may be helpful in making a determination. And do know that if the taxpayer not-for-profit does submit an exemption application and the PWA denies that exemption application in whole or in part, the taxpayer does have the right to appeal to the Indiana Board of Tax Review 45 days after the determination is sent by the PWA, by the county. Some examples are easier than others. I mentioned religious organizations, a church, a mosque, a temple. Those generally would be pretty cut and dry cases. But then you get into some situations where maybe there's mixed use and other factors relating to the use. I know in some areas, especially maybe more rural areas, you have post offices, for example, United States Postal Service, that they maybe have satellite locations. And so what property use code do you use? Well, it obviously goes back to the use of the property, but if the main hub or property is being used, it would have a class code of 600. The satellites probably would have a class code of 429. The question then becomes, well, should the satellites, it's all privately owned, should they be tax exempt? And it all comes back to looking at the situation and specifically looking at the lease agreements. And we'll talk about leases in greater detail in a minute, but it is fact case sensitive. And certainly if you do have any questions or issues that come up, while we try and be as helpful as possible, a lot of times I will refer you or ask you to seek specific legal advice, guidance from your county attorney, because they're there to represent you, and also they would be more aware of the situation, be able to work with you directly on situations like a post office. So with leased property, there is a specific code citation. You can see Indiana Code 6-1.1-10-37 talks about leases of exempt property, and when is it exempt and when is it not exempt. And again, you have to look at a case-by-case basis, but typically the real property and the personal property will be exempt if it's leased to another person or taxpayer whose property is not exempt. Excuse me, is exempt. So you just have to look at the leases and see what does the lease call for. There may be some situations where the taxpayer has to give notice to the county assessor of leases of certain property. And you can see what happens, especially in the case of the lessor of exempt state or political subdivision property leasing to an entity other than a non-profit entity or government entity. What happens in that situation? There would have to be, you can see the criteria, the existence of the lease, the terms of that lease, and the name and the address of the lessee. So if you get into a situation with leased property, please look through it, work with your county attorney to determine, is it tax exempt, not exempt, what needs to be provided to make a determination. One of the questions we get in terms of common issues or problems that come up is if a for-profit entity owns a building but leases a portion of that building to a nonprofit entity, is that portion of the building leased to the nonprofit entity exempt from property taxes? And 14 years ago, there was a case, Hamilton County, Peterborough versus the Oak and Bucket Partners. And in this situation, there was a for-profit business owned an office building, and they were leasing property to a church, and they were trying to claim or get the property tax exempt for that portion of the property that was leased to the church. And basically the tax court came back, and the decision was that leasing property to an exempt organization does not qualify the titled owner, so in this case, say the office building owner, to the charitable property tax exemption. For property to qualify for that charitable exemption, the taxpayer must demonstrate that its property is owned for exempt purposes, or occupied for exempt purposes and predominantly used for exempt purposes. So in other words, in this case, the Oak and Bucket Partners would have had to have demonstrated that they also were an exempt entity and be able to prove that in order to get the exemption for that portion that they leased to that church. So what happens if a for-profit entity owns a building but leases a portion of the building to a state agency? Is that portion of the building leased to the state agency exempt from property taxes? The answer is yes, if the lease requires the state agency to reimburse the owner for property taxes. So again, you have to look at it on a case-by-case, lease-by-lease basis to see if there could be a partial exemption. If there is a partial exemption, you can see then under 6-1.1-10-2, it would be a partial exemption equal to the amount of the gross assessed value for that real property that is occupied or leased by the state agency. So let's talk about a few Indiana Board of Tax Review cases and also Indiana Tax Court cases. The first one I want to bring up is from Allen County versus Lutheran Homes. This is October 2023, so almost a year ago. But in this case, Lutheran Homes wanted to create or have a continuing care retirement community, a senior living facility, and Lutheran Homes claimed that it was a charitable use exemption for that. It was property. It was called Piper Trail. It's in the southwest part of Allen County. One of the key things to know about this Piper Trail property is it wasn't just a charitable situation per se. They had entrance fees for over $200,000 just to join, plus monthly rents. And so the IBTR ruled that in this situation, it did not qualify for a charitable purpose, in part because even though Lutheran Homes may have been exempt from different perspectives, they conceived of, planned, and operated this one development, Piper Trail, in a commercial manner. And so you can see that while Lutheran Homes may have addressed some of the non-financial needs, that possibly could qualify as charitable, it did so in a commercial manner and not a charitable manner. And I won't go into too much more detail about this, but the tax court gave little weight to Lutheran's status as a non-for-profit corporation. As I mentioned earlier, just because they claim they're a 501c3 does not automatically state that it's going to be exempt. And the tax court ruled that you have to look and see what is the use of the property, that the property's exemption is tied to its use. Another case from almost a year ago was Napanee Power from the Past versus Elkhart County Assessor. And in this situation, the owners, a not-for-profit board, they had applied for an exemption for property was purchased from Amish Shakers up in Elkhart County, and they claimed that they were 100% exempt based on the code citation as far as charitable and educational use for the 50-acre property. And in this case, it was 50 acres. They had several buildings on the property, and the taxpayer claimed that it was dedicated to, for community purposes, especially as educating the public about agricultural farm implements and traditions. And one of the key portions of this was that this area, this facility, this property only had a few events during the year. They had 4 events per year, which included tractor pulls and participation in an apple festival. And so the question became, well, how much time is devoted? What is it? Even though wind power charged fees for attendance, the property was closed to the public the rest of the year, and they stored farm implements there. And so now the question becomes, well, what is the predominant use? Even though the property was incorporated to educate and facilitate discussion about antique farm implements and other information, that the assessor's office claimed that they showed no charitable use of the property, and the IBTR decided otherwise. That it came back to the predominant use. So even though there may have only been 4 festivals per year, the rest of the time, the predominant use of that facility was for charitable and educational purposes. And one of the things the IBTR pointed to was in the Klein Museum case, and this was a tax court decision. In this case, there was a 1-person hobbyist who owned and operated a property that had military history items. And in that situation, even though it was open only occasionally to the public, the IBTR had held that the taxpayer was tax exempt. Another contention or part of the situation in the Napanee Power case was that maybe the not-for-profit wasn't as well managed or wasn't as well run as others. And the IBTR noted that they're not really concerned or looking at the not-for-profits management per se. They're looking at what is it being used for? Does it meet the criteria to be exempt? So even though the taxpayer, the not-for-profit may not have been the best managed, most successful not-for-profit, the IBTR did grant them a 100% exemption for the property, except for one barn that was zoned for a family business. We mentioned or talked about medical facilities, hospitals a little bit ago, and so now I want to shift over and talk about a case from October of 2010. And in this case, it was the St. Joseph Regional Medical Center versus the St. Joseph County Assessor's Office. And so St. Joseph Regional Medical Center sought an exemption for various properties and buildings that they had, medical pavilions that they rented to physicians and other medical providers, and the PDVOA in their determination said that it was 63% exempt and 37% taxable. And just a little bit of background, the St. Joseph Regional Medical Center is a not-for-profit corporation, and they operated a hospital during the periods in question, and the parcels contain 3 medical pavilions. And mentioned that the the percentage use was 63%. However, one of the things involved with this was that St. Joseph did not employ other tenants, and they did not receive any of the tenants' income, and they charged what they thought was market rent. And one of the things that the tenant doctors from this case claim was that they were available to the hospitals residents. They did some teaching, whatever some teaching may be, in conjunction with the being tenants, and they were supportive of emergency room staff if they were needed. What does supportive of emergency room staff needed as needed mean? And as you can see, St. Joseph claimed that, hey, because these doctors that we're running to, that they're available teaching, they should be exempt as well. And you can see, generally speaking, not-for-profit hospitals are maintained to relieve the destitute and deserving are charitable, but other property does not automatically receive a charitable purpose exemption. So even though you have a not-for-profit hospital owns a property, it comes back to the use. And so I think a key takeaway, again, is to look at each case by case not-for-profit situation, be it a hospital or a farm area, or whatever the case may be, and look as what is the property being used for, and what is for the exempt entity to be exempt. They have to be able to prove that they do meet the criteria. So in this situation, just because St. Joseph Hospital said, yeah, we have these and we're supportive of our inpatient facility, you have to be able to prove it, be able to show it that it is meeting the intent. So in this case, St. Joseph lost the case. Another case, this goes back even further, back to March of 2003, involves Parkview Memorial Hospital versus the Allen County Peterborough. Similar in terms of, we're looking at healthcare hospital. The Parkview Memorial Hospital appealed to the IBTR after their Peterborough determinations denied. The Peterborough denied their exemption applications. The petitioner contending that they met charitable care, and then we'll talk about it, indigent care here in a minute. But the assessor said, nah, not so fast, that the charitable acts were de minimis or minimal in terms of what they did, and therefore they should not be qualified for an exemption. So in this case, the property was a medical office building located in Fort Wayne, and also all the personal property included. As I mentioned, the Peterborough determined that they were 100% taxable. And here again, much like we talked about some others, Parkview Health Systems is a non-for-profit corporation, and they were exempt from federal income tax under 501c3. That does not guarantee that you're going to be exempt for property tax purposes. The corporation required the doctors it employed to assist in its charitable care by providing care to indigent individuals, and then also being involved in community benefit oriented programs. So the taxpayer said, yeah, it's small, but we're still, we're still furthering our charitable cause, and that's why we should be exempt. And they didn't think the percentage or amount of time that was given towards indigent care really mattered, and that you have to look at the big picture. Meanwhile, the assessor's office said, yeah, it does matter how much time you're spending with indigent care and community-related events, and there must be some sort of standard that you set for giving an exemption. And then, so in order to be exempt, there are 3 standard tests. In this case, one is the predominant use that we've talked about, the substantial relation test, and then charity care or community benefit. So how much of your time are you doing providing, for the property, at the property? The determination was that the petitioner presented no evidence that the predominant use was for providing indigent care or community benefits, and so the amount of charitable care just was not sufficient to justify being tax exempt. Hence, the property was 100% taxable. Another case, and this is more recent, this is 5 years ago, the St. Mary's Building Corporation versus the Warwick County Assessor's Office. Certainly encourage you, if you have not already read it, to go to the tax court's website and read it, because it is a very interesting case, and the assessor's office did a lot of work to defend its decision, and it can have long-lasting implications. But here, basically what happened is the tax court held that St. Mary's Building Corporation, even though they were a holding company for the property, did not prove that the other parts of the campus and buildings that they own should receive a charitable or religious exemption. So this goes all the way back to 2014 and 15 tax years, but the building corporation wanted to get exemptions for the building and 2 parcels, the medical group and the breast care facility. And the Warwick County PETA found that it was 100% taxable for both years. The taxpayer obviously appealed. The building corporation stated they were a not-for-profit corporation, and it held deeds to the parcels on appeal, including a medical building as known as the St. Mary's Epworth Crossing building. And they sought a charitable and religious exemption for Epworth Crossing, and they sought exemptions also for personal property, not only at Epworth Crossing, but also at the hospital, medical group, and the breast center. They sought an 82% exemption, which they said is the proportion of the facility leased to those three locations. In this case, it really centered on one critical issue, and that's the relationship between the operations at Epworth Crossing and the hospital's inpatient facility care. And the building corporation claimed that all the space that it's on exemption for was owned and operated by the hospital as inpatient hospital, or provide care in an inpatient facility. The tax court, as you can see, said exemptions under Indiana law are highly fact sensitive. That's been what I've been trying to relay during the past few minutes here, and that there's no bright line test per se for whether or not it is. You have to look at it on a case-by-case basis, and that the language of one case may not necessarily be applicable to another case. You just have to look at it, each exemption on its own. So in this case, the predominant use test was needed in terms of the exemption amount, and specifically what are they looking at in terms of the amount of care provided. As I mentioned to start with, in terms of looking at the exemption, you have to look at the prior year. And I'll repeat it again, the taxpayer must demonstrate that it's owned, occupied, and predominantly used for an exempt purpose during the relevant tax year. And that could change from year to year. Depends on the situation. Maybe one year it's 50%, 60%, 70%. So you have to look at it potentially on a year-by-year basis, especially for those that are given a percentage basis. And as you can see in the tax court's decision, it said property owned by an exempt hospital does not automatically receive a charitable purpose exemption. Rather, the charitable purpose exemption does not apply to other property owned by a hospital that is not substantially related to or supportive of its inpatient facility. So there has to be relationship. There has to be a tie-in between, say, the main hospital, the main facility, and other buildings or other properties related to that. A key thing I mentioned, doing a time study. Well, in this case, the building corporation did not provide a time usage study. So if you're entitled to it or want it, you have to be able to prove or show here's why, and here's the breakdown of how much time is spent with it, be it 83%, 85%, 90%, 70%, whatever the case may be. So the tax court ultimately held that the building corporation failed to show that this Epworth crossing had a charitable use for an exemption, and it did not meet the standard for a religious exemption. We get several questions from taxpayers, from assessors, tax representatives, a variety of people throughout the year. So I went through and came up with or culled my emails to see what were some of the most frequently asked questions. So the first one is, I have a church that is going to be running out their kitchen 2 days a week to a gentleman who is starting his own coffee shop. Would this area still receive the 100% exemption, or would it be based on a percentage based on the days rented out? I didn't mention this, but in 2017, there was a court case involving Hamilton County and the Duke taxpayer. And this goes back to keeping time records. So we mentioned for churches, if the predominant use is more than 50% of the time, they would still get the 100% exemption because it is a church or religious organization. If it were a different type of property, let's say it wasn't a church that owned the property but they were exempt, but they were renting out to a individual like this, then you'd have to look and see, well, how much time is being used for the charitable purpose? Is it 70% of the time, 60% of the time? How much time is involved? The church sold their property to a couple for personal use in June 2024. When should the religious exemption come off? So the exemption would come off for 2025, payable 2026. So even though the property may have sold mid-year, the exemption that was on the books for January 1st, 2024 would stay in place and would come off then in 2025. We have one of our county public schools reach out over a tax bill they received. It is for a parcel with a dwelling that sits next to the school. Am I correct that just because a public school owns the property, it does not make it automatically tax exempt? We have another county public school that owns farmland behind their superintendent's office that is cash rented, and they are taxed for that land. So again, looking at it on a case-by-case basis, unless the county is aware of a lease agreement that would make the property subject to taxation, then probably in this situation, the property owned by a political subdivision, including school corporations, by default would be exempt. When an exempt property sells, is it up to the assessor's office to present the transfer to the PETA for the exemption removal? If the assessor misses the transfer and fails to remove the exemption, does the auditor's office have the authority to remove the exemption? First, the taxpayer hopefully is filing a Form 136 CO/U, which is change of ownership use. And assuming that the new owner is not exempt eligible, the assessor doesn't necessarily need to go to the PETA for their approval to remove it. They could if they wanted to, but it's not required. And if for whatever reason the assessor missed the title or missed the transfer, yes, then the auditor could go in and remove it. Again, back case sensitive, you may want to check with your county attorney for specific legal advice and guidance. So having said that, Jenny, do we have questions?
Yes, we do. We have a couple. The first one is, if a library purchases a property but intends on renting it out, will that still fall under their exempt status?
It depends. I hate to give a wishy-washy answer, but it depends. And who is the library leasing the property out to? Is it the library leasing it out to a not-for-profit? Is the library leasing the property out to a for-profit entity? How much of the property is going to be used for potential charitable, education, religious, exempt purposes? So, like I said, it really depends on the situation. So I'd hate to say carte blanche, yes, the property would be exempt. I'd hate to say carte blanche, the property is not exempt. It really just depends on the situation and how long, when is that library, when are they leasing the property out, and how much of the property are they leasing out? Next question.
Okay. Next question is, when was the last date that nonprofits had to file a 103 or a 104 if under 80,000? Do they have to file them 5 years in a row on time to be eligible for that?
Oh, good question. I will have to follow up. I don't remember the specifics on this. I do know, I believe it was for churches, that if they'd, been filing a personal property return for 5 years, they would not have to, but I'd have to check on other not-for-profit. So I'll answer that in better detail when we put out our responses later, in terms of all the other questions we received. So I hate to give a non-answer answer, but I don't know specifically to that question. So
that is our last question for right now.
Okay.
If there are anyone else that has a question, you can go ahead and enter that into the chat function there, and we'll get that answered. As Barry mentioned, and I mentioned earlier, we will take all of the questions that we received both from this morning and this afternoon and put that together in an FAQ document, so that everybody has those questions and can get those answers as well. While we wait to see if anybody else has any more questions, I'll do a couple quick housekeeping wrap-up items. First off, as a reminder, we will send out an email later this week that will include the PowerPoint, the video, the survey, and the CE form. We do already have on the website the PowerPoint, the PDF version of those documents, as well as the survey and the CE form. So you can go ahead and access that. We'll get the video posted as soon as possible, and then we'll be sending out an email to those that were pre-registered, as well as posting the video on our webpage later this week. So if you want to reference those later, you can. You can also share that with other individuals who may be interested in this same topic, so that they can also get CE credit. If you watch it later, you just need to self-report that on the form and submit that to our office. If you're an assessor, you'll submit that to our office and send that to education@dlgf.in.gov. If you are a different elected official, you will send it to or submit that to your governing body or association, and follow up with them as to how to record that information. As a reminder, next month we will have IBTR giving us a presentation on their new online filing system, Poplar. So if you have not already registered for that session, we do encourage you to go ahead and sign up for that. I think it'll be really informative. We don't typically have guest speakers, but wanted to extend this opportunity to IBTR as they have this new system coming online, and making sure everybody is aware of the changes that are coming. So it doesn't look like we have any more questions now, but if you do have any questions or have any immediate concerns, please reach out to Barry or your assessment field rep, and they will be able to get you a response right away. But we want to thank you all for joining us today, and hopefully we'll see you in October when we do the presentation with IBTR. Thank you all for joining us today.